Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Divorce laws vary significantly by state and are subject to frequent legislative changes and judicial interpretation. The information provided here is based on historical trends and general legal principles common in the Sunbelt region, but should not be used as a substitute for the counsel of a licensed attorney or certified financial professional in your specific jurisdiction. Every case is unique, and potential outcomes are highly dependent on individual circumstances. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified experts before making any decisions related to their legal or financial status. The Sunbelt is often marketed as the ultimate destination for men looking to build a career, enjoy lower taxes, and embrace a higher quality of life. From the tech hubs of Austin and Phoenix to the booming real estate markets of Florida and the Carolinas, the migration to the South and Southwest is a defining demographic shift of our era. However, there is a hidden reality lurking beneath the palm trees and the business-friendly headlines. For many men, the Sunbelt can represent one of the most volatile legal environments for the dissolution of a marriage. In states like Texas, Florida, and Arizona, the family court system operates under frameworks that can catch the unprepared completely off guard, potentially leading to the loss of 40, 50, or even 60% of a lifetime's worth of accumulated assets in a matter of months. While the region is known for its conservative fiscal policies, its family courts often lean into aggressive redistribution of wealth and strictly defined custody schedules that may not align with the modern father's lifestyle. If you are a high earner or a business owner living in this region, you are navigating a landscape where the rules of the game change the moment you cross state lines. This deep dive masterclass is designed to solve one specific, high-stakes problem: the information gap that leaves men vulnerable during a Sunbelt divorce. Today, we are breaking down the architectural differences between the various legal systems in the region, so you can understand the potential outcomes of your specific situation. We are moving past the surface-level advice and looking at the historical trends of how judges in these specific states treat separate property, business valuations, and spousal support. By the end of this series, you will have a comprehensive understanding of the strategic landscape, allowing you to move from a position of reactive fear to one of informed preparation. This is not about winning or losing. It is about the preservation of your future and the stability of your children's lives in a region that handles these transitions with surgical and often brutal efficiency. To understand the Sunbelt divorce, we must first look at the massive geographic and legal divide within the region itself. The Sunbelt is generally divided into two distinct legal philosophies: community property states and equitable distribution states. This distinction is the single most important factor in determining how your bank accounts, retirement funds, and real estate holdings will be divided. In the Western Sunbelt, specifically Texas, Arizona, and New Mexico, the system is governed by community property law. This is a historical holdover from Spanish civil law, and its logic is deceptively simple. Anything acquired during the marriage belongs equally to both spouses, regardless of who earned the paycheck or whose name is on the title. In a state like Texas, the starting point for a judge is often a 50-50 split of the entire marital estate. However, the complexity arises when we look at the historical trends of just and right divisions. Texas judges have the discretion to deviate from that 50-50 split based on factors like fault in the breakup of the marriage, disparity of earning capacity, and the health of the parties. For a man who has spent 20 years building a private medical practice or a construction firm, the community designation can be devastating if he cannot prove through a process called tracing that certain assets were owned prior to the marriage or were received as a specific inheritance. Contrast this with the Eastern Sunbelt states like Florida, Georgia, and North Carolina, which follow the principle of equitable distribution. Here, the word equitable does not mean equal. It means fair. While this might sound more flexible, it actually introduces a higher level of unpredictability into the process. In a Florida court, a judge will look at a list of statutory factors to decide who gets what. They consider the contribution of each spouse to the marriage, including contributions as a homemaker, the economic circumstances of each party, and the duration of the marriage. In these states, historical trends show that if a man is the primary breadwinner, the court may lean toward a distribution that attempts to bridge the gap between his post-divorce lifestyle and his spouse's, which often results in a significant transfer of assets that goes beyond a simple half-and-half split. A critical trap that men in the Sunbelt frequently fall into is the residency requirement and the race to the courthouse. Because the Sun Belt attracts so many transplants, jurisdiction is often a contested battleground. In states like Nevada, you only need to be a resident for 6 weeks to file for divorce. In Texas, it is 6 months in the state and 90 days in the specific county. We have seen case studies where one spouse moves to a more favorable state, waits out the residency clock, and files first to secure a legal advantage. This is particularly relevant for men who have homes in multiple states, such as a primary residence in Georgia and a vacation home in Florida. The difference in how those two states treat alimony or alimony reform can result in a swing of hundreds of thousands of dollars over a decade. For example, Florida recently passed major legislation that overhauled its alimony laws, moving away from permanent periodic alimony toward more limited, rehabilitative structures. A man filing in Florida today faces a very different potential outcome than he would have just 5 years ago. Furthermore, we must address the no-fault reality that defines the Sun Belt. Every state in this region allows for a no-fault divorce, meaning neither party has to prove adultery, cruelty, or abandonment to end the marriage. While this was intended to reduce conflict, it has historically created a blindside effect for men who believe their conduct within the marriage should protect their assets. In an Arizona court, for instance, the fact that a spouse was unfaithful usually has zero impact on the division of property. The court treats the marriage like a business partnership that is being liquidated. However, there is a caveat: wasteful dissipation of assets. If a spouse spent marital funds on a paramour, expensive gifts, or gambling in Las Vegas, the court can reconstitute the estate, essentially charging those expenses against that spouse's share of the remaining assets. As we go deeper into this deep dive masterclass, we will explore the specific step-by-step details of asset characterization. In the Sun Belt, the burden of proof is almost always on the person claiming an asset is separate property. If you entered a marriage with a brokerage account worth $200,000 and you spent the next 10 years trading stocks, reinvesting dividends, and perhaps moving some of that money into a joint account for a down payment on a home in Scottsdale, you have commingled those funds. In the eyes of a Sun Belt judge, that separate property may have been transmuted into community or marital property. Without meticulous record-keeping and a clear paper trail, the historical trend is for the court to default to the assumption that everything is marital. This is why the discovery phase of a Sun Belt divorce is often the most grueling part of the process, requiring forensic accountants to look back through years of digital statements to find the original, separate core of an investment. Finally, we have to consider the cultural and demographic pressure on the Sun Belt courts. These are some of the fastest-growing legal systems in the country, and they are often overwhelmed. This leads to a heavy reliance on mediation and standard possession orders. In Texas, the law has a presumed schedule for fathers that, until recently, was quite rigid. Understanding the expanded standard possession order is a vital step for any man who wants to maintain a 50-50 parenting split in a state that historically favored a primary and possessory conservator model. The Sun Belt is transitioning, but the legacy of the old guard remains in many rural counties, creating a geographic lottery where the outcome of your divorce depends heavily on whether your case is heard in a major metro area like Charlotte or a smaller, more traditional judicial circuit. This first part of our deep dive sets the stage for a granular look at the financial and parental hurdles that define the modern American divorce in the South and Southwest. Moving immediately into the financial architecture of a Sun Belt divorce, we have to address the single most expensive mistake men make in this region: the failure to understand asset characterization. In the high-growth corridors of the South and Southwest, your wealth is likely tied up in 3 primary buckets: real estate, retirement accounts, and professional businesses. In 2026, with the Sun Belt housing market remaining a primary engine of American wealth, the way a court looks at your home or your investment portfolio can be the difference between a secure future and a decade of financial recovery. Historical trends in states like Texas and Arizona show that courts lean heavily on the concept of inception of title. This means the character of an asset, whether it is separate property or community property, is determined at the moment you first acquired it. However, the complexity of modern finance in 2026 makes this anything but simple. Imagine a character named John, a software engineer who moved to Austin in 2019. John bought a home for $500,000 before he married his wife in 2021. By 2026, that home is worth $1.2 million. John assumes that because he bought the house before the wedding, the property is his alone. Under Texas law, he is technically correct about the title, but he is walking into a trap regarding community reimbursement. Over the 5 years of his marriage, John used his salary, which is considered community property the moment it is earned, to pay down the mortgage and perhaps renovate the kitchen. In a divorce, the community estate may have a reimbursement claim for the value of those mortgage payments and the appreciation tied to those renovations. John might keep the house, but he may have to liquidating other assets just to pay his spouse for the value the community contributed to his separate property. Case studies from the Phoenix metro area highlight a similar phenomenon with retirement accounts. Let us look at David, a project manager in the construction industry. David had $300,000 in his 401k before his marriage in 2020. During the marriage, both he and his employer continued to contribute. In 2026, the account has grown to $800,000. In a Sun Belt community property state, the court does not just look at the total balance. They use a tracing analysis. The original $300,000 and the passive growth on that specific amount remain David's separate property. However, every dollar contributed during the marriage, plus the growth on those specific contributions, is considered community property. If David cannot provide every single monthly statement from the last 6 years to prove exactly when the growth occurred, the court may default to treating a larger portion of that account as community property. This historical trend of the burden of proof being on the person claiming separate property is why the discovery phase in 2026 is more data-intensive than ever. Beyond the standard accounts, we must look at the deep dive of business valuations, which is a major factor for men in the Sun Belt's entrepreneurial hubs like Charlotte or Miami. If you own a business, the court treats it as a divisible asset. There is a critical distinction here between enterprise goodwill and personal goodwill. Enterprise goodwill is the value of the business that exists regardless of who is running it, such as its location, its systems, and its brand. Personal goodwill is the value tied directly to your specific skills, reputation, and relationships. Historical trends in Florida and North Carolina show that while enterprise goodwill is a marital asset subject to distribution, personal goodwill is often excluded. However, the process of separating the two requires a forensic valuation expert. Imagine if you own a specialized medical practice or a high-end consulting firm. The spouse's legal team will argue that the business's success is an enterprise asset, while your team must argue that the revenue walks out the door when you do. In 2026, valuation models have become increasingly sophisticated, and a failure to prepare for this specific battle can lead to a court ordering a payout based on an inflated valuation of a business you cannot actually sell. Now, imagine a scenario where you received an inheritance or a gift during the marriage. Many men believe this is a safe zone. If your parents left you $200,000 in 2023, and you deposited that money into a joint brokerage account where you also keep your annual bonuses, you have created a commingling disaster. Once those funds are mixed, they are like two different colors of paint poured into a single bucket. You cannot simply unpour them. To a judge in the Sun Belt, that inheritance has likely been transmuted into community or marital property. Potential outcomes in these cases often result in the person who received the gift losing half of it simply because they lacked the foresight to keep the funds in a segregated account. This is why the first step-by-step detail of any deep dive strategy in 2026 is a total audit of your financial history to identify every instance of commingling before the legal process even begins. The 2026 economic landscape adds another layer of difficulty: interest rates and refinancing. In previous decades, a common potential outcome was for one spouse to buy out the other's interest in the family home by refinancing the mortgage. In the current market, if you have a 3% mortgage from 2021, and you are forced to refinance in 2026 to pay out your spouse's equity, your monthly payment could double or triple. This creates a massive financial bottleneck. Historical trends now show more men being forced to sell their homes entirely because the cost of a buyout is no longer sustainable. This is not just a legal hurdle. It is a mathematical reality of the Sun Belt's high cost of living areas. Another area where the Sun Belt differs from the rest of the country is the treatment of professional degrees and licenses. While some states in the North treat a professional degree as a marital asset with a tangible value, states like Texas generally do not. However, they do consider the disparity in earning power. If you spent the marriage becoming a high-earning executive while your spouse stayed home, the court in an equitable distribution state like Georgia will use that disparity to justify giving the spouse a larger share of the tangible assets, such as the liquid cash or the equity in the home. They are essentially balancing the future earning potential of the man against the immediate assets of the marriage. Step by step, the financial discovery process involves a mandatory exchange of documents. In 2026, this includes not just bank statements, but cryptocurrency wallets, digital payment histories like Venmo and Zelle, and even your electronic toll tags to verify your whereabouts and spending habits. The level of transparency required is absolute. If a man tries to hide assets in a Sun Belt court, the historical trends suggest that judges are increasingly punitive. We have seen case studies where a man was found to have funneled money into a separate offshore account or a private crypto wallet, and the judge responded by awarding the entirety of the remaining domestic assets to the wife. The potential outcomes of non-disclosure are almost always worse than the outcomes of a strategic, transparent defense. As we move through this masterclass, it is becoming clear that the financial battle is won or lost in the documentation. But even with all the money in the world, the most intense and emotionally draining part of a Sun Belt divorce is not the bank account. It is the schedule. The way these states handle the time you spend with your children is shifting, and the traditional every other weekend model is being challenged by new legislative standards. However, the fight for 50-50 custody in the Sun Belt has its own set of traps, especially when it comes to the geographic restrictions that can prevent you from moving for work or family. You have secured the strategy for the money, but do you have a strategy for the time? In the next part, we are going to dive into the reality of custody battles in 2026 and why your zip code might be the most important factor in your relationship with your children. While the money is being counted, the clock is ticking on your parental rights, and the Sun Belt courts have a very specific way of measuring that time. In the Sun Belt, the clock is not just a tool for keeping time. It is a ledger for your parental rights. As we sit here in 2026, the legal framework governing where your children sleep and who makes their medical decisions has undergone a quiet but radical transformation. In the high-growth corridors of the South and Southwest, the historical trends have shifted from a traditional maternal preference to a system that, on paper, favors joint involvement. However, the gap between the written law and the potential outcomes in a courtroom is where many men lose their footing. To navigate this, you must understand that in states like Texas, Florida, and Arizona, custody is not a single concept but a divided set of rights: legal custody and physical possession. Let us look at a case study involving Michael, a technical lead at a semiconductor plant in Phoenix. In 2026, Michael is going through a divorce after 12 years of marriage. He has 2 children, ages 8 and 10. Michael's primary goal is 50-50 custody. In Arizona, the law has moved toward a rebuttable presumption that equal parenting time is in the best interest of the child. This sounds like a win for Michael, but the step-by-step reality of a Phoenix courtroom is more nuanced. The court looks at the status quo. If Michael's job required him to be at the plant for 60 hours a week while his spouse handled the school runs and doctor appointments for the last decade, a judge might view a sudden shift to 50-50 as a disruption to the children's stability. This is the stability trap. To counter this, Michael must document his actual involvement. In the Sun Belt, the trend is moving away from testimony and toward digital footprints. This includes logs from parenting apps like Talking Parents or Our Family Wizard, which have become the gold standard for evidence in 2026. Imagine if Michael lived in Texas instead of Arizona. The landscape changes instantly. Texas does not use the word custody. They use conservatorship. The law presumes that both parents should be joint managing conservators, or JMC. But here is the catch. JMC does not mean 50-50 time. It simply means both parents share the right to make decisions about education and healthcare. The actual schedule is governed by the Standard Possession Order, or SPO. Historically, the SPO gave the non-primary parent the first, third, and fifth weekends of every month. For a man in 2026, this is often insufficient. However, Texas has expanded the options. If Michael lives within 50 miles of his children, he can opt for the expanded Standard Possession Order. This gives him the kids from Thursday when school lets out until Monday morning when school starts, every other week. This historical trend toward expansion has allowed men to move closer to an actual 50-50th split, but it requires a proactive legal filing. If you do not ask for the expansion in your initial response, you might default back to the old-school weekend model. The most dangerous factor in your relationship with your children in 2026 is the geographic restriction, often called the residency bubble. Because the Sun Belt is a land of transplants and economic migration, courts are obsessed with stability. In states like Georgia and North Carolina, once a divorce is filed, a temporary order usually prevents either parent from moving the children outside of a specific geographic area, often limited to the current county and those immediately surrounding it. Imagine if Michael, while his divorce is pending in Dallas, is offered a massive promotion in Charlotte, North Carolina. If he takes that job and moves, he risks losing primary possession. Historical trends show that judges are extremely reluctant to allow a parent to relocate children away from the other parent if it breaks the current visitation schedule. Case studies in 2026 show that men are increasingly being forced to choose between their career trajectory in the booming Sun Belt economy and their ability to see their children more than 4 days a month. This is the zip code factor. Your mobility is effectively frozen the moment the petition is served. Now, we must address the financial link to custody. In the Sun Belt, child support is almost always tied to the number of overnights. In Florida, for example, if a parent has more than 20% of the overnights, it triggers a different calculation in the child support formula. This creates a perverse incentive structure where custody battles are sometimes motivated by a desire to reduce or increase monthly payments. In 2026, Florida's laws have become even more rigid regarding these calculations. If Michael reaches a 50-50 split in Tampa, but his income is significantly higher than his spouse's, he will still likely pay child support, but the amount will be drastically lower than if he only had the children every other weekend. The potential outcomes of a custody battle can shift your monthly cash flow by thousands of dollars, making the parenting plan a central pillar of your financial survival. The best interests of the child standard is the legal yardstick used across the entire Sun Belt. Sounds subjective, and it is. Judges have immense discretion. They look at the emotional ties between the child and each parent, the capacity of each parent to provide food and medical care, and the moral fitness of the parents. In 2026, moral fitness has largely moved away from old-fashioned judgments about lifestyle and toward a focus on co-parenting. If Michael spends his time in court disparaging his spouse, the judge will see him as a parent who will likely interfere with the other parent's relationship with the child. Historical trends show that the parent who appears most willing to facilitate a relationship with the other parent is the one who often gets the tie-breaking vote on major life decisions, like where the child will attend school. Step by step, you must build what is called a parenting portfolio. This is not just a collection of photos. It is a log of every school meeting you attended, every coach you spoke to, and every pediatric appointment on your calendar. In 2026, Sun Belt judges are looking for a primary caretaker, or at least a highly involved second parent. If you cannot name your child's dentist or their math teacher, you are starting at a disadvantage that no amount of legal maneuvering can fully overcome. You are fighting against a historical inertia that still views the father as the provider and the mother as the nurturer. While the laws are changing, the cultural baseline of the judiciary in many Sun Belt counties is still catching up. Furthermore, we have to look at the right of first refusal. This is a common clause in Sun Belt parenting plans that states if one parent is unable to watch the children for a certain period, usually 4 to 8 hours, they must call the other parent before hiring a babysitter. In 2026, with many men in the Sun Belt working in high-demand sectors like aerospace or logistics, this clause can be a double-edged sword. It can provide you with more time, but it can also be used as a surveillance tool by an ex-spouse to monitor your social life or work schedule. Understanding how to cap the hours on this clause is a vital tactical detail. As we look at the intersection of time and money, a new reality is emerging in the Sun Belt. The rise of remote work in 2026 has complicated the residency bubble. If both parents can work from anywhere, the argument for staying in a high-cost county like Travis or Miami-Dade becomes harder to justify. Yet, the courts remain anchored to the physical location of the school. The school district is the ultimate anchor. If you want to maintain your parental rights, you must be prepared to live within a short radius of that anchor, regardless of where your office is located. We have covered the money and we have covered the time. But there is a third silent force that can destroy even the best legal strategy: the weaponization of the legal system itself through temporary orders and domestic allegations. While you are counting your overnights and checking your bank statements, a single filing can change the rules of engagement overnight, potentially barring you from your home and your children before you even have a chance to speak to a judge. This brings us to the dark side of the Sun Belt divorce. In the next part, we are going to look at the immediate actions you must take the moment a divorce is imminent to protect yourself from the predatory use of temporary restraining orders and the loss of access to your own property. The game is about to get much more aggressive, and if you do not know how the system can be turned against you, you have already lost. The strategic strike is the moment the theoretical possibility of divorce becomes a physical reality. In the legal community of the Sun Belt, this is often referred to as the shock and awe phase. It is a period defined by the filing of a petition accompanied by a request for temporary orders, which can fundamentally alter your life before you have even had the chance to respond to the initial summons. In 2026, the speed at which these orders are processed has only increased due to digital filing systems and the high volume of cases in growth centers like Atlanta, Charlotte, and Orlando. If you are not prepared for the first 72 hours, the potential outcomes for the remainder of your case can be severely compromised. To understand the weight of this phase, let us examine a case study involving Marcus, a renewable energy consultant living in Orlando, Florida, in early 2026. Marcus is at work when he is served with a stack of papers that include not just a petition for dissolution of marriage, but an ex parte injunction for protection against domestic violence. In the legal world, ex parte means that the judge heard testimony or read an affidavit from only one side, Marcus's spouse, without Marcus being present or even aware of the hearing. Based solely on that one-sided account, a judge signed an order that requires Marcus to vacate his 5-bedroom home in Lake Nona immediately. He is barred from coming within 500 feet of his spouse or his children. He is not allowed to return for his clothes, his passport, or his work laptop without a police escort. This is the reality of the kick-out order. Historical trends in Sun Belt states like Florida and Texas show that judges, when faced with even unverified allegations of volatility or fear, will almost always err on the side of caution. The court's primary objective in the early stages is the preservation of the peace and the safety of the children, and they are often willing to displace a father temporarily to achieve that. For Marcus, this creates an immediate crisis of access. Because he is barred from the home, he is also effectively barred from his children. If he tries to call his spouse to explain or reason with her, he is in violation of a court order, which in 2026 is a criminal offense that can lead to immediate arrest. This is the first and most critical trap, the temptation to react emotionally to a legal maneuver. Beyond the physical exclusion, we must address the financial freeze known as the standing order. In many Sun Belt jurisdictions, such as Gwinnett County in Georgia or Maricopa County in Arizona, the court issues an automatic standing order the moment a divorce is filed. This order is designed to maintain the status quo of the marital estate. It strictly prohibits both parties from selling, transferring, or encumbering any assets, and from making any large withdrawals from bank accounts outside the ordinary course of business or for reasonable legal fees. Imagine a scenario where Robert, a logistics executive in Atlanta, sees the writing on the wall in 2026 and decides to move $50,000 from a joint savings account into a private account held by his brother. Robert thinks he is protecting his future. In reality, he has just committed a violation of a standing order. When this comes to light during discovery, the court may view Robert's actions as fraudulent or as a sign of bad faith, which can lead to punitive distributions of the remaining assets. The predatory use of domestic allegations is a heavy topic, but one that must be understood through the lens of historical trends. In high-conflict Sun Belt divorces, the strategic filing of a temporary restraining order, or TRO, is sometimes used not because of actual violence, but to gain leverage in custody negotiations. By securing an order that keeps the father out of the house, the filing spouse establishes a new status quo where they are the sole caregiver. In 2026, when courts are looking at stability as the primary factor for children, being away from your kids for even 3 or 4 weeks while waiting for a return hearing can be devastating. Step by step, the response to such a strike must be clinical. You do not argue with the process server. You do not send an angry text. You immediately secure a professional legal team to file a motion to dissolve or modify the injunction, and you begin the process of gathering objective evidence, such as doorbell camera footage, text history, and third-party witness statements, to refute the allegations at the first available hearing. Digital hygiene is another pillar of this deep dive masterclass. In the Sun Belt's tech-heavy hubs, your digital footprint is often the most significant piece of evidence against you. The moment a divorce is imminent in 2026, you must assume that every email, every private message, and every search query is discoverable. Historical trends show that many men lose their cases because of messages sent in moments of frustration. Furthermore, if you share a family cloud account or a synchronized set of devices, your spouse may have real-time access to your location, your browser history, and your communications with your attorney. A vital step-by-step detail is the immediate change of all passwords, the implementation of two-factor authentication on a device that is not shared, and the auditing of any shared accounts. This is not about hiding information. It is about protecting your right to privileged legal counsel and preventing the unauthorized monitoring of your daily life. The hearing on temporary orders is the first time a judge will actually see both sides, and it is perhaps the most important day of the entire process. This hearing sets the rules for the next 12 to 18 months. The judge will decide who stays in the house, who pays the mortgage, how much temporary child support or alimony will be paid, and what the parenting schedule will look like. In a Sun Belt court, these hearings are often very short, sometimes only 20 or 30 minutes per side. This means your evidence must be organized with surgical precision. If you are a man in 2026 facing this hearing, you must have your financial affidavits completed to the penny. Any inconsistency in your reported income or expenses can lead a judge to believe you are being less than transparent, which usually results in a higher support obligation. In states like North Carolina or South Carolina, the court might also appoint an amicus attorney or a guardian ad litem during this early phase. These are third-party professionals tasked with investigating the best interests of the children. They will visit your home, talk to your children's teachers, and observe your interactions. In the Sun Belt, the reports generated by these individuals carry immense weight. Historical trends suggest that judges will follow the recommendations of a guardian ad litem in the vast majority of cases. Therefore, your first interaction with these professionals is high stakes. You must be prepared to show, not just tell, how you have been an active, involved parent. The game is not just about who has the best lawyer. It is about who has the best system for managing the overwhelming amount of data that a 2026 divorce produces. While you are defending against allegations and fighting for access to your home, the court is also looking at your ability to provide for your family's future. This brings us to the financial engine of the Sun Belt divorce: the calculation of support. While you are navigating the emotional minefield of a TRO, the cold math of alimony and child support is already being calculated behind the scenes. In the next part, we are going to break down the specific formulas used in the Sun Belt, the recent legislative reforms that have changed the way spousal support is awarded, and why your career growth in 2026 might be viewed as a shared asset rather than your own achievement. The temporary orders were just the beginning of the financial transition. Now we look at the long-term drain and how to navigate the support structures of the South. The financial architecture of a long-term Sun Belt divorce is built on two primary pillars: child support and spousal maintenance, or alimony. While the temporary orders we discussed previously provided a short-term fix to keep the lights on, the final orders in 2026 are designed to redistribute your future income for years, or even decades. In the South and Southwest, the formulas for these payments have become increasingly rigid, yet they still contain specific trapdoors that can catch a high earner off guard. To navigate this, you must understand that the court is no longer looking at your marriage as a romantic union. They are looking at it as a dissolved economic partnership where you may be designated as the primary funding source for two separate households. Let us start with the cold math of child support. In the Sun Belt, there are two main philosophies for calculation: the percentage of income model and the income shares model. To see how this plays out, imagine a character named Christopher, a senior medical device sales rep in Houston, Texas. In 2026, Christopher earns a base salary plus significant performance bonuses, totaling $250,000 annually. Texas follows a modified percentage of income model. The law sets a cap on the amount of net resources subject to the standard percentage. As of 2026, the historical trend has been for the Texas legislature to adjust this cap upward every few years. If Christopher has 2 children, the court typically applies a 25% multiplier to his net resources up to that cap. However, if his spouse can prove that the children's proven needs exceed that capped amount, the court can go above the guidelines. This is where the step-by-step detail of a lifestyle analysis becomes critical. If the children were enrolled in elite private schools in the River Oaks area or participated in high-level competitive sports, the court might order Christopher to pay significantly more than the standard state maximum to maintain the children's established standard of living. Now compare Christopher's situation to James, a cybersecurity architect in Atlanta, Georgia. Georgia uses the income shares model, which is common throughout the Eastern Sun Belt. In this system, the court looks at the combined income of both parents and consults a state-mandated table to find the basic subsistence amount for the children. That amount is then divided proportionally between the parents based on their respective incomes. If James earns 70% of the total household income, he is responsible for 70% of that base amount. However, Georgia's formula also includes mandatory adjustments for healthcare premiums and work-related childcare costs. In 2026, with the cost of health insurance and high-end daycare in Metro Atlanta skyrocketing, These add-ons often eclipse the base support amount. James must also be aware of the parenting time deviation. Historical trends in Georgia show that if he manages to secure a true 50-50 parenting split, he can request a downward deviation in his support obligation, but it is not automatic. He must prove that his direct expenditures on the children during his time justify the reduction. Beyond child support lies the more contentious realm of alimony, or spousal maintenance. In the Sun Belt of 2026, the era of permanent alimony is largely a relic of the past, but the alternatives can be just as draining. Florida, once the national epicenter of permanent alimony, underwent a massive legislative shift that fully matured by 2026. The new standards prioritize durational, rehabilitative, and bridge-the-gap alimony. Imagine James's cousin, Robert, who is divorcing in Tampa after a 20-year marriage. Under the old laws, Robert might have faced a lifetime of payments. In 2026, the court follows a strict formula based on the length of the marriage. For a marriage of 20 years, alimony might be limited to a maximum of 75% of the duration of the marriage, or 15 years. Furthermore, the amount is often capped at 35% of the difference between the spouse's net incomes. While this provides an end date, it still represents a massive long-term liability. The most dangerous concept for a high earner in the Sun Belt is the imputation of income. This is a legal maneuver where the court decides to base your support obligations not on what you are currently earning, but on what they believe you are capable of earning. Imagine if Christopher, feeling the burnout of the 2026 medical sales world, decided to quit his high-stress job and take a lower-paying role at a local nonprofit just as the divorce was filed. The court will look at his work history, his specialized degrees, and the historical trends for his position in Houston. If the judge determines Christopher is voluntarily underemployed to avoid support, they will impute his income at the $250,000 level. He will be ordered to pay child support and alimony based on money he is no longer making. This creates a financial death spiral where the debt to the state and the ex-spouse begins to accrue immediately, often with interest. Step by step, the way to defend against aggressive imputation is through a vocational evaluation. You may need to hire an expert to testify that the job market for your specific skill set has shifted, or that your previous income was based on unsustainable overtime that is no longer available. In the Sun Belt's rapidly evolving economy, what you earned in 2024 may not be a fair reflection of what you can earn in 2026. This is especially true in sectors like commercial real estate or traditional manufacturing, which have seen significant volatility. Another factor that men in the Sun Belt must consider is the tax treatment of these payments. Since the federal tax changes that took effect years ago, alimony is no longer tax-deductible for the payer, and it is not considered taxable income for the recipient. In 2026, this means that if Robert is ordered to pay $4,000 a month in alimony, he is paying that with post-tax dollars. To actually have $4,000 in cash to send to his ex-spouse, Robert might need to earn $6,000 or $7,000 in gross income. This hidden tax burden effectively increases the cost of alimony by 30 to 40% for the man, making the negotiation of the total amount even more critical. We must also discuss the concept of career growth as a shared asset. While Sun Belt states generally do not award a spouse a literal percentage of your future raises, they do look at the disparity in earning power created during the marriage. If you spent the last decade climbing the corporate ladder in Charlotte while your spouse stayed home, the court sees that your increased earning capacity was made possible by the other spouse's domestic contributions. In an equitable distribution state like North Carolina, this disparity is a primary justification for awarding the spouse a larger portion of the liquid assets, such as the 401k or the home equity, as a way to offset their lack of independent retirement security. They aren't taking your future paycheck directly, but they are taking the current assets to compensate for the fact that your future paycheck will be much larger than theirs. As you move through the financial discovery process, the court will require a detailed financial affidavit. In 2026, this is not a document you can rush. It requires a line-by-line accounting of every monthly expense, from your mortgage down to your streaming subscriptions and gym memberships. Historical trends show that men who underestimate their own living expenses often end up with a support order that leaves them with a deficit at the end of the month. You must be prepared to prove your own cost of living with the same vigor that your spouse's attorney will use to prove theirs. The support structures of the Sun Belt are designed to ensure that the lower-earning spouse and the children do not become a burden on the state. This means the pressure is entirely on the higher-earning parent to maintain two households on a single income stream that has now been split by the court. While the money is being allocated, another silent threat is emerging. As you calculate your monthly payments and analyze your 2026 tax brackets, you might realize that your legal fees are beginning to rival your support obligations. The Sun Belt is home to some of the most aggressive litigation tactics in the country, and the cost of the battle itself can sometimes eclipse the value of the assets you are fighting over. This leads us to the critical world of professional fees, expert witnesses, and the strategic use of mediation to stop the bleeding. In the next part, we are going to look at how to manage the cost of the divorce itself and why the smartest men in the Sun Belt are the ones who know when to settle and when to fight. The financial drain is not just in the alimony, it is in the process, and we are going to show you how to keep the professionals from taking what the court leaves behind. The professional machine of a Sun Belt divorce is fueled by one thing: your liquidity. As we move into 2026, the cost of litigating a high-conflict case in major hubs like Dallas, Miami, or Phoenix has reached a point where the process itself can become a larger financial burden than the actual settlement. You are not just paying for a lawyer. You are funding a small army of professionals including paralegals, junior associates, forensic accountants, and specialized appraisers. In the Sun Belt, where the marital estates are often heavy with complex real estate holdings and tech sector equity, the historical trends show that legal fees can easily climb into the six-figure range before you ever see a trial date. Let us look at the concept of the interim attorney fee award, which is perhaps the most frustrating financial reality for men in the South. Imagine a character named Andrew, a successful medical tech entrepreneur in Scottsdale, Arizona. In 2026, Andrew is the primary breadwinner, while his spouse has not worked outside the home in a decade. When the divorce is filed, Andrew's spouse may file a motion for interim fees. In states like Arizona or Texas, the court has the authority to order the spouse with more financial resources to pay the other spouse's legal fees up front. This is designed to ensure a level playing field, but for Andrew, it means he is effectively paying for the very person who is suing him. He is funding two sets of lawyers to fight over his own assets. Historical trends in 2026 show that these awards are becoming more common as courts aim to prevent one spouse from starving the other out of the litigation. The second massive drain on your resources is the use of expert witnesses. In a deep dive masterclass on Sun Belt law, we cannot ignore the forensic accountant. If you have any separate property claims, such as an inheritance or a business you started before the marriage, you will likely need a professional to perform a tracing. This is a step-by-step reconstruction of every dollar that moved through your accounts over the course of the marriage. In 2026, a high-level forensic accountant in a city like Austin or Charlotte can charge between $400 and $700 per hour. For Andrew, whose business involves complex intellectual property and multiple layers of equity, the cost of just valuing his company for the divorce could exceed $50,000. This is a non-negotiable expense. Without a professional valuation, the court might rely on a simplified and potentially inflated number provided by the opposing side. Imagine if the case also involves a custody dispute. Now, the roster of experts expands to include a custody evaluator or a guardian ad litem. These professionals are tasked with investigating the family dynamic and making a recommendation to the judge. Their fees are typically split between the parents, but in 2026, the higher earner is often tagged with a larger portion of the bill. These evaluations are incredibly invasive and time-consuming, involving psychological testing, home visits, and interviews with extended family. If you find yourself in this situation, you are not just fighting a legal battle. You are being audited as a parent and a provider simultaneously. Step by step, you must learn to manage your legal team like a business. This means reviewing every monthly invoice for what is known as block billing. In 2026, law firms are increasingly using automated tracking software, and you need to ensure you are not being charged for 10 different people to read the same email. A common pitfall for men is using their attorney as a therapist. At $500 an hour, an emotional vent session is the most expensive conversation you will ever have. Historical trends show that the men who keep their communications clinical, organized, and focused on the facts are the ones who manage to keep their legal fees from spiraling out of control. This leads us to the most critical crossroads in the Sun Belt divorce process: mediation. In many jurisdictions such as Florida and North Carolina, the court will not even give you a trial date until you have attempted mediation. Mediation is a structured negotiation facilitated by a neutral third party, often a retired judge or an experienced family law attorney. For Andrew in Scottsdale, mediation represents the best chance to stop the financial bleeding. In 2026, the trend is toward full-day or multi-day mediation sessions. The process is grueling. You and your attorney sit in one room, your spouse and their attorney sit in another, and the mediator shuttles back and forth with offers and counteroffers. The goal is a mediated settlement agreement, which once signed is usually irrevocable. This is where the strategy of the settle or fight calculation comes into play. Imagine the mediator comes to Andrew and says his spouse is willing to walk away for an extra $100,000 in the property split. Andrew's initial reaction might be to refuse on principle. However, his attorney points out that going to trial will take another 6 months, cost an additional $75,000 in legal and expert fees, and carries the risk that a judge might award his spouse even more. In the Sun Belt, where the judiciary is often backlogged and judges are prone to splitting the difference to clear their dockets, the potential outcomes of a trial are highly unpredictable. Andrew has to decide if the certainty of a settlement is worth the premium he is paying to end the case today. Case studies in 2026 suggest that over 90% of Sun Belt divorces settle in mediation, not because both sides are happy, but because the cost of continuing the war has become unsustainable. However, mediation in 2026 has a new trap: the exhaustion factor. These sessions often go long into the night, and as the hours pass, decision-making ability declines. You must be prepared for the marathon. This means having your bottom line clearly defined before you walk into the room, and refusing to be pressured into a deal that compromises your long-term stability just to end the day. A step-by-step preparation for mediation includes creating a range for every asset: your walkaway number, your target number, and your opening offer. Without this roadmap, you are just reacting to the mediator's pressure. We must also consider the role of the offer of judgment or the proposal for settlement. In some Sun Belt states, if you make a formal settlement offer and the other side rejects it, only to get a worse result at trial, they may be forced to pay your legal fees from the date of the offer. This is a powerful tactical tool used to force a stubborn spouse to be more reasonable. In 2026, these proposals are being used with surgical precision to end cases that have no business going to trial. While you are navigating these high-stakes negotiations and managing your professional fees, the reality of the finality of the process is beginning to set in. You are not just dividing a past, you are building a new, separate future. But what happens if mediation fails? What happens when the professionals can no longer bridge the gap, and you find yourself standing in front of a judge who will decide the rest of your life in a matter of hours? The Sun Belt courtroom is a place of high drama and cold logic, and the transition from negotiation to trial is where many men find their final stand. In the next part, we are going to dive into the mechanics of the final trial, the rules of evidence in 2026, and how to present your best self when the stakes are at their absolute highest. You have managed the costs and survived the mediation, but now the gavel is about to fall. Standing at the threshold of a Sun Belt courtroom in 2026 is a sobering experience that strips away the abstractions of legal theory and replaces them with the high-stakes reality of judicial discretion. When mediation fails and the settlement discussions go cold, you enter the trial phase, which is essentially the final liquidation of your previous life. In the South and Southwest, trials are typically bench trials, meaning there is no jury. One person, the judge, sits as the ultimate arbiter of your finances, your parenting ability, and your future mobility. In 2026, these courtrooms are more efficient and more digitally integrated than ever, but they remain places where a man's life can be reshaped by the stroke of a pen in a matter of hours. You must understand the mechanics of this environment, the evolved rules of evidence, and the psychological weight of the witness stand to survive this final stand. The first thing you must grasp is the sheer speed of a 2026 bench trial. Due to the massive population growth in Sun Belt hubs like Nashville, Austin, and Phoenix, the court dockets are perpetually overcrowded. This has led to a historical trend of judges imposing strict time limits on each side. Imagine a character named Thomas, a senior commercial pilot based in Charlotte, North Carolina. Thomas is fighting for 50-50 custody and a fair division of his substantial retirement assets. His attorney informs him that the judge has allotted exactly 4 hours for the entire trial. That is 2 hours for Thomas's legal team and 2 hours for his spouse's team. Every minute spent on an irrelevant story or an emotional outburst is a minute lost for critical testimony. This time-compressed environment means your evidence must be presented with surgical precision. In 2026, the rules of evidence have expanded to fully embrace the Internet of Things and advanced digital forensics. We are no longer just talking about printed emails or text messages. Imagine if Thomas's spouse introduces data from his smart home system or his Tesla's GPS history to prove he was not at home during his designated parenting time in 2025. In the Sun Belt, historical trends show that judges are increasingly receptive to this type of passive data. Step by step, the authentication process for this evidence involves verifying the metadata and the digital chain of custody. If you cannot explain why your fitness tracker shows you were at a gym 40 miles away when you claim to be helping with homework, the court will view this as a major blow to your credibility. In 2026, your digital footprint is your most honest witness, and it can be used to either bolster or betray you. The witness stand is the center of the trial's gravity. When it is your turn to testify, you are subjected to direct examination by your lawyer and cross-examination by the opposing counsel. This is where many men falter by failing to understand the difference between being a good person and being a good witness. Case studies in 2026 suggest that men who try to win the argument with the opposing lawyer often lose the case with the judge. Imagine if Thomas is on the stand, and the opposing attorney begins a line of aggressive questioning about his travel schedule. If Thomas becomes defensive, interrupts, or attempts to explain away every minor inconsistency, he appears volatile and untrustworthy. The strategic move is to answer with brevity. Yes, no, or I do not recall are the most powerful tools in your arsenal. The judge is not looking for you to win the debate. They are looking for your temperament. Judicial perception is an invisible but dominant force in Sun Belt courtrooms. While the law is written in black and white, its application is colored by the judge's individual philosophy. In more conservative Sun Belt counties, there may still be a lingering subconscious bias toward traditional gender roles. To counter this, your presentation must be beyond reproach. In 2026, this means dressing with the same level of respect you would for a high-level board meeting, and maintaining a stoic, professional demeanor, even when your spouse's attorney is presenting a distorted version of your life. Historical trends show that judges respond favorably to men who appear as the emotional anchor of the family, the parent who is focused on the children's stability, rather than seeking revenge for the marriage's failure. A critical step-by-step detail of the trial is the management of expert witnesses. As discussed in previous parts, the forensic accountant or the custody evaluator will often testify at trial. In 2026, their testimony is often delivered through a combination of live appearances and pre-recorded digital summaries. You must be prepared for the cross-examination of these experts. If your spouse has hired a vocational expert to argue that you could be earning more, your lawyer must be ready to challenge that expert's datasets and methodologies. In the Sun Belt's rapidly shifting economy of 2026, using outdated employment data from 2023 or 2024 is a common mistake that your team must exploit. The trial is essentially a battle of competing narratives, and the narrative supported by the most credible data usually wins. The concept of the rebuttal is the final chance to address new issues raised during the trial. If your spouse's team introduces a witness who makes a surprising allegation, you may have a few minutes at the end of the trial to provide a counter-testimony. This is not the time for a long-winded defense. It is the time for a specific, evidence-backed correction. Imagine Thomas has a friend who can testify that he was actually at a community event during a time he was accused of being absent. This witness's testimony is a surgical strike designed to restore Thomas's credibility, just before the judge retreats to chambers to make a decision. In Texas, there is a unique quirk that men must be aware of: the possibility of a jury trial for certain issues like the determination of the primary conservator. While rare and expensive, a jury trial changes the entire strategy. You are no longer appealing to a single legal mind but to 12 citizens from your community. Historical trends in Texas show that juries can be more unpredictable than judges, sometimes awarding custody based on a parent's perceived moral character, rather than a strict reading of the best interest standard. In 2026, opting for a jury trial in a Sun Belt divorce is a high-risk, high-reward move that requires a massive investment in jury consultants and trial exhibits. Once the trial concludes, the judge may issue a ruling from the bench immediately, or they may take the case under advisement and issue a written decree weeks later. This decree is the final word. It will detail the division of every bank account, the sale or transfer of real estate, the exact schedule for your children, and the precise amount of support you will pay or receive. In the Sun Belt, the finality of this document cannot be overstated. While modifications are possible, they historically require a material and substantial change in circumstances, such as a significant job loss or a relocation. You cannot simply ask for a redo because you do not like the outcome. As the gavel falls and you walk out of that courtroom, the legal battle may be over, but the financial and logistical rebuilding is just beginning. You are now a single man in a region with high costs of living and a complex tax landscape. The decree tells you what you lost and what you kept, but it does not give you a roadmap for how to survive in the post-divorce economy of 2026. Many men find that the most difficult part of the process is not the trial itself, but the first 6 months of living under the terms of the decree. This brings us to a critical, often overlooked area of the masterclass: the tax traps and financial rebuilding strategies that define the aftermath. You have survived the courtroom, but can you survive the IRS and the high inflation environment of the modern South? In the next part, we are going to dive into the post-divorce financial audit, the 2026 tax implications of asset transfers, and how to protect your remaining wealth from the silent drain of the transition. The trial was the storm. Now we must talk about how to rebuild the house. Rebuilding the house after a Sunbelt divorce requires a shift from legal warfare to cold-blooded fiscal management. By the time the final decree is signed in 2026, most men are emotionally exhausted and ready to stop thinking about their finances. This is a critical mistake. The historical trends of post-divorce financial recovery suggest that the first 12 months of your new life are just as important as the 12 months of litigation that preceded them. You have been handed a set of assets and a set of liabilities, but you have likely inherited a hidden partner in your new venture: the Internal Revenue Service. Understanding the 2026 tax implications of your settlement is the only way to ensure that the wealth you fought to keep does not evaporate through the silent drain of tax characterization and carryover basis. To illustrate this, let us look at a case study involving a character named Brandon, a senior project manager for a civil engineering firm in Nashville, Tennessee. In his 2026 divorce settlement, Brandon fought hard to keep the family home in a high-demand suburb like Franklin. The home is valued at $1.4 million. To keep the house, Brandon agreed that his spouse would take $700,000 from their joint brokerage and retirement accounts. On paper, Brandon kept 70% of the total equity he built during the marriage. He believes he has secured his financial foundation in one of the fastest-growing real estate markets in the Sun Belt. However, Brandon is walking into the carryover basis trap. Under Section 1041 of the Internal Revenue Code, transfers between spouses incident to a divorce are generally non-taxable at the time of the transfer. But this is not a tax-free gift. It is a tax-deferred liability. Brandon's cost basis in the house is what he and his spouse originally paid for it back in 2015, which was $400,000. When Brandon eventually decides to sell that house in 2028 or 2030 to downsize or relocate for work, he will face a capital gains nightmare. Because he is now filing as a single man, his primary residence exclusion is limited to $250,000. If he sells the home for $1.6 million, his gain is $1.2 million. After his $250,000 exclusion, he is paying taxes on $950,000 of profit. In 2026, with capital gains rates being a constant subject of legislative debate, Brandon could be looking at a tax bill of over $200,000. His spouse, meanwhile, walked away with $700,000 in cash and liquid securities that she can reinvest with a much higher degree of flexibility. This is why a step-by-step net worth audit must include a tax-adjusted valuation of every asset. The next structural hurdle is the Qualified Domestic Relations Order, or QDRO. This is the legal instrument used to divide retirement accounts like a 401k or a traditional pension without triggering immediate taxes or early withdrawal penalties. In 2026, the administrative complexity of QDROs in the Sun Belt has increased as employers move toward more complex benefit structures. Imagine a character named Steven, an aerospace engineer in Mesa, Arizona. Steven has a high-value 401k and a legacy pension plan. The court orders a 50-50th split. The step-by-step execution of this is grueling. First, Steven's attorney must draft a specific order that meets the exact requirements of the plan administrator at his company. Second, that order must be pre-approved by the plan. Third, a judge must sign it. Fourth, the final signed order is sent back to the plan for implementation. Historical trends show that many men fail to follow through on the final steps, leaving their retirement accounts in a state of legal limbo. If Steven's spouse decides to withdraw her portion immediately in 2026, she is responsible for the taxes, but the QDRO ensures Steven is not penalized for the distribution. Failure to use a QDRO for these transfers can result in the entire amount being treated as a taxable distribution to the account owner. potentially pushing Stephen into the highest possible tax bracket for 2026. Beyond the tax traps, we must address the cost of living reality of the modern Sun Belt. In 2026, cities like Austin, Tampa, and Phoenix are no longer the affordable havens they were a decade ago. As a single man, you are now managing a household without the economies of scale that come with a dual income or shared expense marriage. If you are paying child support and alimony based on 2026 standards, your discretionary income is likely tighter than it has ever been. Historical trends in the South show that many men attempt to maintain their pre-divorce lifestyle to prove they are still doing well, leading to a rapid accumulation of high-interest debt. The strategic move is an immediate, aggressive restructuring of your personal burn rate. This means auditing every subscription, every insurance policy, and every discretionary expense to align with your new post-decree cash flow. In states like Florida and Texas, which have no state income tax, the burden is often shifted to high property taxes and sales taxes. If Brandon keeps that $1.4 million home in Tennessee, he is responsible for the property taxes, the maintenance, and the skyrocketing insurance premiums that have defined the Sun Belt insurance market in 2026. Many men find that while they won the right to keep the house is now a liability that prevents them from rebuilding their investment portfolio. Potential outcomes often include a strategic sale of the marital home within 18 months of the divorce to unlock liquidity and reduce monthly carrying costs. Step by step, the financial rebuilding process should involve the creation of a new, separate estate plan. Your final decree likely removed your ex-spouse as a beneficiary of your life insurance and retirement accounts by operation of law, but historical trends suggest you should never rely on state statutes to protect your heirs. In 2026, you must proactively update your beneficiary designations and your will. If you have children, you may need to establish a trust to ensure that any life insurance proceeds are managed by a trustee you choose, rather than defaulting to the control of your ex-spouse as the children's legal guardian. This is a critical detail for men in high-growth regions where asset values are significant. Furthermore, we must look at the impact of the 2026 economic environment on your professional growth. If you are a high achiever in a Sun Belt tech or energy hub, you may be tempted to aggressively pursue promotions or new ventures. However, you must be aware of the modification trap. In many Sun Belt jurisdictions, a significant increase in your income can be grounds for your ex-spouse to file for an upward modification of child support. While the law varies by state, the historical trend is that as your lifestyle increases, the children's standard of living should increase proportionately. Before you accept that high-stakes VP role in 2027, you need to run the numbers on how much of that raise will actually stay in your pocket versus how much will be redirected through the court system. We have addressed the hidden taxes, the administrative hurdles of retirement, and the cold reality of the Sun Belt's high-cost economy. But money is only half of the rebuilding process. As you stabilize your bank account, you are also navigating a social and personal landscape that has been completely transformed. The Sun Belt is a region of high-speed social dynamics, and the way you transition from a married man to a single father or a single professional in 2026 involves more than just a balanced checkbook. It involves the management of your reputation, the protection of your peace in a high-conflict co-parenting environment, and eventually, the re-entry into a dating market that has changed radically since the last time you were in it. You have protected the wealth, but can you protect the man? In the next part, we are going to look at the psychological and social transition, the traps of the 2026 dating scene for divorced men, and why your social media presence might be the next target for a post-decree legal strike. The financial house is being rebuilt, but now we must talk about the life you are going to live inside it. The transition from a man undergoing a legal process to a man living a post-decree life in the Sun Belt is often described as a second adolescence, but one with significantly higher stakes and much more expensive mistakes. In the high-octane social environments of 2026, particularly in cities like Austin, Scottsdale, and Miami, your status as a divorced man is not a private matter. It is a data point that is tracked, analyzed, and often weaponized. The psychological shift required here is total. You are moving from a world where your identity was anchored in a family unit to one where you are a solo actor in a hyper-competitive, digitally transparent society. Historical trends in these regions show that men who fail to manage this social transition often find themselves back in court within 24 months, facing what we call the post-decree legal strike. This strike is rarely about the law itself and almost always about the perception of your new lifestyle. To understand the mechanics of the post-decree strike, imagine a character named Alex, a director of operations for a logistics firm in Phoenix, Arizona. It is late 2026, and Alex has been divorced for 10 months. He has stabilized his finances and is finally starting to enjoy the fruits of his labor. He takes a week-long trip to a high-end resort in Cabo San Lucas and, in a moment of celebration, posts a few photos on his Instagram. One photo shows a first-class ticket, and another shows him at a dinner that clearly costs several $100s. To Alex, this is just a vacation. To his ex-spouse and her attorney, this is evidence of a substantial and material change in financial circumstances. In the Sun Belt, where modifications of child support or alimony are common, those photos can trigger a motion for discovery. The historical trend in 2026 is for courts to allow for a re-examination of income if a party's outward lifestyle appears significantly inconsistent with the financial affidavits filed during the divorce. Alex now faces a potential outcome where his child support is increased or his alimony duration is challenged, all because he failed to maintain a low digital profile. Step by step, you must implement a policy of digital invisibility for the first 2 years post-divorce. This does not mean deleting your accounts, but it means treating your social media like a legal ledger. In 2026, AI-assisted monitoring tools are often used by high-conflict law firms to scrape the public profiles of former opposing parties. If you are tagged in a photo at a charity gala, a new car dealership, or a high-stakes sporting event, that data is archived. The strategy here is simple. If it is not in the decree, do not put it on the feed. Your social circle in the Sun Belt needs to be vetted with the same rigor as your business partners. Historical trends show that many post-decree strikes are initiated because a mutual friend shared information about a new promotion or a significant purchase with the ex-spouse. In the tight-knit professional circles of Charlotte or Nashville, reputation is currency, and a whisper campaign can lead directly to a courtroom. This brings us to the 2026 dating landscape for divorced men in the South and Southwest. The Sun Belt is home to some of the most active dating markets in the country, but in 2026, the rules have changed. We are now living in the era of the background check culture. Before you even finish your first drink at a bar in Buckhead or the North Loop, there is a high probability that your date has already run your name through a vetting app or a public records database. In states like Florida and Texas, divorce records are generally public. This means your new partner can potentially see the exact terms of your settlement, your custody schedule, and any allegations that were made during the trial. Potential outcomes for men who are not transparent about their situation include immediate social excommunication. The case studies of 2026 show that transparency is the only defense against the digital vetting process. You do not need to share details, but you must acknowledge the reality of your situation before the algorithm does it for you. Furthermore, you must navigate the phenomenon of lifestyle creep. In the competitive social scenes of the Sun Belt, there is a massive pressure on divorced men to prove they have still got it. This leads to the purchase of the midlife crisis vehicle, the luxury apartment in the city center, and the aggressive pursuit of a lifestyle that your post-divorce budget may not truly support. Historical trends suggest that this is the primary cause of post-divorce bankruptcy in the region. When you combine high inflation, high interest rates, and a heavy support obligation, the margin for error is razor thin. Imagine if Alex, in an attempt to impress a new partner, signs a lease on a penthouse that consumes 40% of his take-home pay. If his company undergoes a restructuring in 2027, he has no safety net. He is one missed paycheck away from a contempt of court filing for failure to pay support. The goal is not to look successful, it is to be sustainably solvent. Co-parenting in 2026 has also moved into a new digital frontier. The Sun Belt leads the nation in the adoption of parenting coordination apps. These platforms are designed to reduce conflict, but they also create a permanent, discoverable record of every interaction. A common trap for men is the use of these apps for emotional venting or passive-aggressive scheduling changes. In a 2026 courtroom, a judge will not look at a year's worth of text messages. They will look at a curated report from the parenting app that highlights your communication frequency and tone. Step by step, you must treat every message to your ex-spouse like a memo to a CEO. It should be brief, informative, and devoid of emotion. If the schedule says the exchange is at 6 p.m. at the Starbucks in Plano, your only message should be, "I am here." Any deviation from this professional tone gives the other side ammunition for a future custody modification. The concept of the parallel parenting model is gaining traction in the Sun Belt as an alternative to traditional co-parenting for high-conflict cases. In this model, each parent makes independent decisions during their time with the children, minimizing the need for contact. This requires a very specific and detailed parenting plan that covers everything from extracurricular activities to hair appointments. In 2026, the potential outcomes for men who embrace parallel parenting include significantly lower stress levels and a reduction in legal fees, as it removes the friction points that lead back to court. However, it requires a disciplined detachment from what is happening in the other household. You have to accept that you cannot control how your ex-spouse parents during their time, provided the children are safe. As you rebuild your life in the Sun Belt, you are also managing your professional reputation. In the tech and finance sectors of the South, a messy divorce can be seen as a sign of personal instability that might affect your career trajectory. Historical trends show that men who keep their personal lives separate from their professional identity during the transition are more likely to secure the promotions and board seats they are after. This is about brand management. You are no longer just a father or an ex-husband. You are a professional who has successfully navigated a complex life transition. We have looked at the social media traps, the dating reality of 2026, and the discipline of post-decree communication. But there is one final piece of the puzzle that most men ignore until it is too late. The legal decree is a document, but the finality of the divorce is a mindset. As you stand in your new home, looking at your bank balance and your parenting calendar, you need a blueprint that brings all these pieces together into a cohesive strategy for the next decade. The transition is almost complete, but the final mastery lies in the long-term execution. In the 10th and final part of this masterclass, we are going to synthesize everything we have learned into the ultimate Sun Belt survival blueprint. We will look at the long-game strategy for wealth preservation, the final checklist for parental legacy, and how to ensure that this chapter of your life is the foundation for your greatest comeback, not the beginning of a slow decline. The house is built, the life is starting, and now we finish the work. The mission does not end when the judge signs the final decree. In the legal and financial reality of the Sun Belt in 2026, the decree is simply the baseline from which you must build your greatest comeback. Many men view the conclusion of a divorce as a finish line, but historical trends suggest that the next 5 years will define your legacy more than the preceding decade of marriage. To master this final phase, we are implementing the ultimate Sun Belt survival blueprint, a comprehensive strategy that synthesizes wealth preservation, parental influence, and the protection of your future assets from the potential outcomes of new relationships. This is where you move from a state of survival to a state of strategic dominance in a region that continues to be the economic engine of the United States. Let us begin with the 2026 wealth reset through a case study of Mark, a commercial real estate developer in Austin, Texas. Mark emerged from his divorce with 40% of the liquid assets he once held and a significant mortgage on a scaled-down property in the Hill Country. In the high-inflation, high-growth environment of 2026, Mark cannot afford to be passive. Step by step, he must implement a capital allocation plan that accounts for the fact that he is now a solo filer for tax purposes. Historical trends in the Sun Belt show that real estate remains a primary wealth builder, but Mark must now pivot toward tax-advantaged vehicles that offer asset protection. In Texas, for instance, a homestead is largely protected from creditors, but Mark's brokerage accounts are not. By 2026, Mark has shifted his focus to maximizing contributions to individual 401ks and utilizing private placement life insurance structures that offer a layer of insulation from potential future litigation. He is not just looking for growth, he is looking for defensible growth. Imagine if Mark meets a new partner in 2027. This is the moment where the most significant post-divorce trap is set. In the Sun Belt, the second marriage failure rate is historically higher than the first. To protect the wealth he is currently rebuilding, Mark must understand the 2026 standards for prenuptial agreements. In states like Florida and Arizona, the enforceability of these documents has become more rigid. A step-by-step detail for a modern prenup involves a full, transparent disclosure of all assets and, crucially, the use of separate legal counsel for both parties. In 2026, courts are increasingly skeptical of prenups signed under duress or without adequate time for review. Mark's strategy is to treat the prenup not as an insult to the relationship, but as a business necessity that defines the character of his separate property. By clearly demarcating his post-divorce earnings as separate, he ensures that if a second dissolution occurs, he is not litigating the same assets for a second time. This is the hallmark of the new Sun Belt man. He is optimistic about the future but realistic about the legal landscape. We must also deep dive into the concept of parental legacy, moving beyond the simple counting of overnights. Consider David, a pilot in Florida whose children are now entering their teenage years in 2026. The 50-50 custody split he fought for is now established, but the challenge has shifted from physical presence to emotional and psychological impact. Historical trends show that as children age, they become more aware of the financial and emotional dynamics between their parents. David's strategy is the implementation of the intentional fatherhood model. This involves a step-by-step plan to involve his children in his world, teaching them about the Sunbelt's economy, financial literacy, and the resilience he showed during the divorce process. In 2026, with the rise of digital distractions, David uses his parenting time to create high-value, analog experiences that build a bond independent of the court-mandated schedule. He is no longer just a possessory conservator. He is a mentor. This long-game approach ensures that when his children reach the age of 18, his relationship with them is based on mutual respect rather than a legal decree. The professional pivot is another critical pillar of the 2026 blueprint. Many men fear that career success will lead to a support modification strike, where an ex-spouse files for increased child support based on a higher salary. However, in the booming tech and energy sectors of the South, stagnating your career out of fear is a losing strategy. The potential outcomes of professional growth almost always outweigh the incremental increase in support obligations. Mark in Austin decides to launch a new investment fund in 2026. He manages the risk of modification by ensuring that his compensation structure is transparent and that he maintains a detailed record of his increased business expenses. Historical trends suggest that courts are more likely to uphold existing support orders if the payer can demonstrate that their increased income is tied to increased professional risk and overhead. You must run toward success, not away from it, while maintaining the documentation necessary to defend your progress in a courtroom. Now, consider the holistic ROI of your health and vitality. In the high-stress corridors of the Sunbelt, from the law firms of Atlanta to the tech hubs of Phoenix, the physical toll of a divorce can be the equivalent of a decade of aging. In 2026, the smartest men view their health as a primary business asset. A case study of David shows that by prioritizing his sleep, nutrition, and stress management, he has maintained a level of professional performance that has allowed him to out-earn his support obligations. The cost of a health crisis in the post-divorce era is astronomical, not just in medical bills, but in the loss of earning capacity and parenting time. Step by step, you must build a routine that offsets the cortisol spikes of the previous years. In the 2026 Sunbelt, vitality is a competitive advantage. As we conclude this masterclass, we must look at the final synthesis of the 10 core principles. You have navigated the dynamic legal disclaimers, survived the high-stakes viral hook of the initial filing, and mastered the complex asset characterization of community and equitable distribution states. You have defended against predatory temporary orders, understood the cold math of alimony and child support, and managed the spiraling costs of the professional machine. You stood your ground in the final trial, navigated the tax traps of the transition, and protected your reputation in the digital age. Now you stand with the survival blueprint in hand. The Sunbelt of 2026 is a land of immense opportunity, but it is also a land of legal complexity for men. The potential outcomes of your divorce were never about a single day in court. They were about the system you built to manage the aftermath. Historical trends indicate that the men who thrive are those who maintain a clinical, data-driven approach to their lives. They view their divorce not as a tragedy, but as a high-cost restructuring of a corporation. They emerge leaner, smarter, and more focused on the long-term legacy of their name and their wealth. While the house is built and the life is starting, the world around you continues to evolve. New laws are being drafted in Florida, Arizona, and Texas as we speak. The economic landscape of 2027 and 2028 will bring new challenges and new opportunities for those who are prepared. This is not the end of your education. It is the beginning of your tenure as the architect of your own future. You have the tools, the case studies, and the step-by-step details to ensure that the Sunbelt remains a place of prosperity for you and your children. The work is finished, but the mission of your life is just entering its most productive phase. As you move forward, remember that the most powerful weapon in your arsenal is not a lawyer or a bank account, but your own clarity of purpose. You have seen the traps and you know how to avoid them. You have seen the potential for recovery, and you know how to seize it. This chapter is closed, and the next one is yours to write. But as one story ends, another begins in the shadow of the shifting legal structures of the American West. What happens when the residency requirements you relied on are challenged by the next wave of migration? The landscape is already changing again. And the next deep dive will uncover the hidden vulnerabilities of the 2027 relocation laws that could put your parenting plan back under the microscope.